I'm Steve Sussman. I'm the Executive Director of the Civil Jury Project, which is an academic center started at NYU Law School 4 years ago. We've been in existence for 4 years. We're the only academic center in the country studying, asking the question, why are civil jury trials disappearing? Indeed, all trials, civil trials, are shrinking. Why is this happening? Should we be concerned that it's happening? And if so, what, if anything, can lawyers and judges do about it? We're not going to reverse the trend, but can we at least stop it? The fact is, as this slide shows, I have a few slides just to show you. You can see the red line there up on the screen. In the last 56 years, the number of jury trials has declined from approximately 10 per sitting federal judge to now under 2 per year. And bench trials, which is the blue line, which surprised us, is going down even further. And that, of course, people say that, well, jury trials are going down because they are too long and they're too expensive, and the result is reviewed frequently as dangerous by corporate defendants. But it's hard to use those arguments to explain the decline in jury trials if you see bench trials going down even quicker. So something else is driving the reduction of all trials in this country. And actually, the United States District Court in Denver, in Colorado, is number 2 in the nation insofar as the number of jury trials, civil jury trials per authorized federal judgeship. The average here is 5. That compares with 2 nationwide. And I suspect that one of the reasons it's high here is because Judge Jackson, as a senior judge, is doing nothing but trying lawsuits.
I'm not a senior judge.
You're not a senior judge.
I look like one, yes.
He's a mature district judge.
Yes, I knew you were a district judge, but I did not know you were great.
I'm a senior comma judge.
Okay. In any event, I mean, how many did you try that? 10 a year? You said you tried 10 a year?
Yeah, probably 10 or 11, probably a year, 12 maybe.
Right. So that obviously does a lot to improve the district's overall average. The nationwide, again, we get the federal court because we look at their statistics because they're readily available and you don't have to go state by state. But the percentage is not only the number of cases that have declined, the number of trials, but the percentage of cases on file which get disposed of by either jury or the bench trials has dropped to well under 1% of all dispositions are now by trial, compared to used to be 5 to 6%. The same thing, and this shows the percentages for the federal district courts in Colorado. It's a downward. It's pretty high compared to other courts, but it's still a downward trend. The state court situation is very much the same thing. You see those lines again. It's downward, a downward trending line, and the average number of civil jury trials and bench trials per Colorado District Court judge and Colorado state courts has also declined. So it's down almost like 1 trial, a little over 1 trial per average judge. And this is what's happening around the country. So one of the things we have done at the Civil Jury Project is to try to study why is this happening, what's driving it, Are there things we can do things about? And we have a website. This is our website that was designed mainly for lawyers and judges to go to. And it has all kinds of things listed, including the names of our advisors. We began in 2015, and it became very obvious at first that if we were going to do something about the trends, we had to begin with getting judges engaged. Judges have got to be interested in trying cases if we're ever going to save civil trials. And there are judges around the country that are very interested and very passionate. We have now over 300 state and federal judges around the country that are advisors to our project. We send them a newsletter. We invite them to exchange views with each other. We hold workshops at NYU for state and federal judges. Over 150 judges around the country have attended those full-day workshops. So there is considerable interest among judges in figuring out what are other judges doing to improve the result of jury trials, to make them less expensive, quicker, more reliable. And there's that interest going on. It's terrific. It's high here in Colorado with the state courts and the federal courts, obviously. And because I heard a lot of places around the country where it's not very high. Another thing we have is a website which we have developed, and this is for people who have either received a summons for jury duty or have already served on jury duty. And if you go here and you've received a summons and you click on that button on the left, you immediately see testimonials from jurors around the country about how it was a terrific experience. And don't not show up, because if you do, you will miss a great experience in your life. If you're currently serving on a jury, you click the middle box that says you should be here. The judge told you not to be here. Come back after you're discharged. And finally, on the end is served on jury duty before. And believe it or not, sometimes we have do you have a verdict? Oh my God.
Good timing.
Good time.
Everybody's here.
So, do you have any time?
They're all here.
Can you come back?
Yeah, but I always talk with the jurors afterwards.
All right, well,
I'll come back. I'll come back, yeah.
you think the jurors want you bring someone down here? That would be fantastic.
I'll ask them.
Ask them to come down here, which would be the best program we'd ever had. Really.
I'll ask them.
That'd be great, Judge. Thank you very much. You're the jurors.
My two law clerks over here have been with me 3 and 4 weeks. And both of them have been constantly in trial since they got here. We've been in trial for 4 straight weeks, 2 different cases. So let me go take the verdict and I'll see if I can get in and come back.
That'd be terrific if they come back. In any event, and we have gotten, if you served on jury duty before, there's a questionnaire. The judges are asked to give their jurors as they discharge them a little card. It says there's a website you can go to. Actually, we had one juror in Denver go to that website, answer the questionnaire, and Ms. Marshall, are you here?
Yeah.
There she is. Would you come sit here? We have one juror that came to our lunch, and we located her through our website. And not because we didn't, unfortunately, we didn't have any other jurors who were able to attend the luncheon event. So we have now got questionnaires completed by people who serve on juries. We encourage judges to distribute those questionnaires. And this is the card they're given, the jurors are given. And we have a social media presence where by using Twitter and Facebook, we get people to go to that jurors or potential jurors to go to that website. So this is the kind of thing we are doing. We thought that at the beginning of the project that we would prepare a list of the reasons why jury trials are declining. And we did, and the list has been changed over time. But on the left, we have things that we are very difficult to change. They're facts of life. And on the right are things which we can change. And we're going to focus on the stuff on the right today. But Ms. Marshall was in a 2-week trial this summer in federal court. A verdict was returned. You deliberated how many hours?
About 4.5.
About 4.5 hours. And one of the questions she asked me when she came in, and when I told her the trials were disappearing, she said, why? So, Judge, why don't we take, Judge, why don't you answer? Do you know why jury trials are disappearing?
Well,
What's your theory?
I have some suspicions. I do think expense is a big part of it. I think that trials are very expensive, and I think they're expensive whether they're bench trials or whether they're jury trials. And that's the common denominator with respect to bench and jury trials. I also wanted to say, Steve, I'm not sure whether your statistics for the federal court in Colorado include magistrate judge trials, but if you did, you would see that the numbers go way up. I've had 3 jury trials this year and 2 bench trials this year already. So the magistrate judges are trying a lot more cases in the District of Colorado this year as well. But I think cost is a big issue. I also think that to a certain extent this boils down to an inability to efficiently try a case, both on the part of the lawyers and on the part of the court. I think that we could do better in terms of training lawyers to try cases and training judges to try cases. One experience I had that I'll talk about very briefly was with a mistrial that I had this year. And it was my first all-female panel. I had 8 jurors, 8 female jurors. There was a person on the panel who I suspected, after the lawyer's voir dire, and I let the lawyers conduct extensive voir dire, would be excused as a result of some of the answers that she gave. She was not excused. She was put on the panel. And I am fairly convinced, after speaking to some of the jurors after the mistrial was declared, that none of them had a very positive experience as a result of the one very disruptive juror who was seated on the panel. And I think that had the lawyers been paying a little closer attention in voir dire and in making their decisions with respect to strikes, preemptive strikes, they would have picked a panel that could have come to a verdict in that case. And so, you know, I'm not laying the blame by any means at the feet of lawyers entirely. There are inefficiencies built into the jury trial process, and we all know that. But there has seemed to me to be perhaps a lack of focus is a better way to put it from some attorneys, and a lack of emphasis on making the experience as efficient and pleasant, for lack of a better word, for jurors as it can possibly be. I understand that a case doesn't end up in a jury trial because everybody likes each other and everybody agrees about everything. I get that. But there is nevertheless a way to try a case to make it seem to be as much about simply the facts and the law as it can be, and not about personalities, and not about sniping, and not about anything else that really is outside the ambit of what we're there to decide in that time period. So those are my thoughts.
So, Judge, does this district do anything special to encourage the parties to go to trial before a magistrate?
Consent. What we did, Steve, was in December of 2011, we changed our local rule with respect to settlement conferences. At that point, the magistrate judges were spending a considerable amount of time on settlement conferences, which took us away from the opportunity to conduct a lot of trials. And the rule changed in such a way that the district judge now has to enter an order for a settlement conference before a magistrate judge. And the philosophy of the court changed to a certain extent, that many parties to civil litigation can afford private mediation. and to have the magistrate judges spend their time on on mediation for free for well-heeled parties might not be the best use of our time. So that change in philosophy about settlement conferences resulted in many fewer settlement conferences being ordered and freed up some of our time. In addition, our rules about not encouraging consent relaxed a little bit, and in part because of a change in philosophy among the active district judges on the bench. And therefore, in appropriate cases and in certain appropriate circumstances, I and my more senior colleagues, Magistrate Judge Hegarty, Magistrate Judge Tafoya, Magistrate Judge Wong, feel comfortable answering questions about consent and telling the parties about the fact that we are experienced trial judges and we're experienced trial lawyers, and that they're really not risking much, we don't think, by consenting to a magistrate judge. We understand that there are some clients who will, under no circumstances,
That's
ever
because they don't want
consent.
a trial.
Well, that's maybe it. It's also because they think that they're getting a
Well,
junior
let me
judge.
ask the audience here. Do any of you think you would always prefer a trial before an Article III judge as opposed to a magistrate judge, not knowing legal, just blank? Does anyone say, I want an Article III judge, I don't care? Does anyone have that view?
They're not going to admit it, Steve.
Well, I mean, I think there are circumstances where one party does not want to go to trial, or is not anxious to go to trial.
I agree.
And they like the case to be in a place where it's moving slowly or not at all. And that's probably one of the big problems.
You know, I'm going to stick my hand up this.
Yes.
I have a different point of view. If I've got a Social Security appeal, I can usually work it out with counsel for the Social Security Administration to certainly try the case before a magistrate judge. That's great. That's fine. It's faster. We like you guys. There's my plug. However, if I've got an ERISA case involving disability, where my client is homeless or highly disabled, they're probably not going to be able to afford private arbitration. So I want an Article III judge to try that case because I want you to be the settlement judge.
Okay.
And I've got a free judge for doing the mediation. So
Yeah.
that's kind of the thinking I have about it.
That's fair enough. I honestly think, though, that the overwhelming majority of cases involve parties who can, in fact, afford private mediation. There are indeed a certain category of cases, and my rough guess is 10 to 15% of the cases, including prisoner cases, where private mediation is out of the question. Because of the...
I would agree with that number. I think about 10% of my clients can
Yeah.
actually afford private mediation.
Yeah, and I definitely understand the strategy as a result of that. It still boils down to having to convince the district judge to enter an order allowing a settlement conference. And there are cases in which, and I make no bones about this, I pick up the phone and say to the district judge, please God, don't make me do a settlement conference in that case. I honestly do. And I explain why. And it often has to do with my perception of the divisiveness between the parties, or what they've put in their confidential settlement statements, or my ability to be persuasive to the attorneys, or my particular frame of mind at that point where I don't really want to spend a day banging my head against the wall, or whatever it might be. But there are also cases in which I take the initiative and call a district judge and say, would you please think about ordering a settlement conference in this case, and here's why. So, but it does come out to be, I think, about 10, 15% of the cases where private mediation is unavailable, and if the parties seek a settlement conference with a magistrate judge, they're likely to get one. And remember this also, that if you have consented to a magistrate judge, and you ask the magistrate judge to order, the presiding magistrate judge to order a settlement conference, the case will be randomly drawn to another magistrate judge to conduct a settlement conference. So you're not giving up the opportunity to have a settlement conference by consenting to a magistrate judge.
Okay, that's interesting. Let me ask this. All the judges here allow lawyers to participate in one year, right? Because you're state judge. And apparently the federal judges in this district allow lawyer participation in one year.
Most do, yes.
Do you impose time limits?
I try to tell the lawyers, look, don't go over 20 minutes per side on this, or in a bigger case, I'll give you 30, 35. I've gone as high as 45. I try to work it out with them in advance of the trial itself and arrive at a reasonable time limit.
So I'd like to know what the judges think about using a questionnaire that is given to the jury panel, the Benary, to complete before voir dire begins, that's more fulsome than the typical stuff you get. Judge Gay, what do you think?
If it's not, let's see if this is, if it's not a homicide or a sex assault, no. I just don't do them in civil cases. They just take up too much time. And if I've got a 3-day car crash case, right? If I have to take what amounts to half a day to fill out questionnaires, the jury's they're way too long. But I do have a sort of a middle thing that I do with that, Steve, is I let the lawyers participate in voir dire, but I also tell the lawyers at pretrial conference that if they have questions that they want me to ask during my voir dire that they think should be asked of the entire veneer, I'll do it. Because look, let's face it, when you ask questions of a jury on voir dire, the jury thinks you've got an agenda. They don't think I have one. So I can ask questions of the jury, and I think I'm going to get a straighter answer than you're necessarily going to get. For example, just an automobile accident case. How many people on the jury have ever had a back injury? Why not let me ask those questions as opposed to having the lawyers use their 20 minutes or 30 minutes or whatever they get to do it? But then the lawyers get to follow up and be very specific and hone in on what they're doing.
So the jury consultants will tell us, and I've heard them speak before, that they think that potential jurors will answer lawyers more honestly than they will answer judges, more candidly. Remember, the judge says, can you be fair? Can you apply the law? Can you follow my instructions? Can you they know the right answer to that question, and that's what they're going to
Yeah,
get.
but that's not the questions I'm talking about. I'm
Yeah, you're talking about a different
I'm
kind of
talking
question.
about case-specific questions concerning the nature of the case and the nature of the claims of the parties. As I said, as general as anybody ever had a neck injury? Anybody ever had a back injury? Anybody ever had a family member that's been in an automobile accident or had a contract claim or had a problem with a landlord? I think they're going to get a more, at least that triggers them from the questions they give me, and it lets the lawyers have information that they need, and it just saves the lawyers questioning for what they want to do.
Judge Blackwell, do you give a question? Do you let a questionnaire be submitted?
Be submitted, not normally. What I do in every civil case is I have a one-page juror questionnaire that prospective jurors complete the morning they report for possible service in the trial. Excuse me. That copies of that are given to counsel, and then I conduct extensive voir dire examination. Counsel have a reasonable period. My default position in a civil action where we're working with 15 prospective jurors initially is 15 minutes, but that's negotiable depending on the kind of case. I never use a questionnaire that is completed before the jurors report for possible service in the trial. Why? Because I've had jurors tell me, well, we sit around the kitchen table and my wife answers some of the questions, Uncle Joe answers some of the questions, we use rhabdination on the rest of the questions, and so we spend a lot of time unraveling those questionnaires and answers during the voir dire examination. I also require by practice standard and trial preparation conference order that you, counsel, submit your proposed voir dire examination questions not less than 5 working days before the commencement of the trial. And then what I do, because I'm eclectic, I simply, if I like your question, I arrogate it without attribution. It becomes my question. And I don't hesitate to do that.
Judge Goldberg?
Yeah, ours is a function of time. We schedule 6 jury trials every Monday, 6. And usually one of them goes. And if we don't have one that goes, somebody else has a conflict, and we take that conflict. We're adding 4 judges this year because we've been operating at 70% capacity, judges to cases, based on what's going on in the state. So recognizing time is critical. We have pre-trials. Counsel come in at 8:30. My law clerk goes down. Stethman goes down at 9 o'clock. And whatever law clerk gets there is the one who's going to be able to pull, the panel and come on up to the courtroom. We usually have them seated by 9:10, 9:15, and we start. I will ask questions that counsel will ask, will have me ask. But my goal is to seat a jury no later than lunch. And in 3 years, we've not failed to do that, because what's really important to me is that next jury trial and making sure that that person is going to have their day in court too, and making sure we get this week trial done within the week.
So explain this to me. With the number of trials going down, those statistics don't lie. Why are we worried about time? Why is anyone concerned that it takes too much time? It looks to me like y'all are underworked insofar as trying to.
You sound like a
I mean,
legislator.
I understand you're doing
That's
things.
actually, I don't think reflects Denver either. Based
Well,
on
it
the trials.
may not accurately reflect certain judges, but, I mean, I go around the country, and I hear these statements, we have to do it this way because it takes too much time, whether it be allowing the jurors to ask questions, or whatever it is, preliminary instructions, it just takes too much time.
I gotta say, Steve, you just brought up the jurors asking questions. We're so far ahead of the curve on that in Colorado. If you don't understand that, when I went back to one of Steve's conferences last October,
Yeah.
I mentioned that we let jurors ask questions, and I also mentioned that in state court, we allow jurors to discuss evidence during the trial, as long as all of them are in the jury room together. Other judges around that room looked like I had grown another head. They were so stunned. Well, how can you do that? And I thought to myself, that's been the default position since, when did we adopt 1.4, Rob? Did they amend, when it's?
05?
Yeah, easy. We've been asking juror questions are the default position in Colorado, and,
Since the 80s.
yeah,
1995.
So,
yeah.
let me ask you.
I was on the state court district bench in southeastern Colorado when then Justice Love Corliss pioneered questions by jurors in civil and criminal cases, and that was in the mid-'80s, so it's been around a long, long time.
Let me ask all the judges. Have you, in the last year, seen a lawyer conduct voir dire that you thought was just, wow, that was an event?
Is hell frozen over?
No. I mean, I think one of the problems is that trial lawyers don't know how to do it anymore. We have lost the ability. There was a time when the purpose of the voir dire in Texas, at least where I'm from, was to win your case. You would be an argument for the moment you stand up. And that caused, of course, because lawyers all over the country were doing that, the federal judges said, you're out of here. You are not going to conduct any more voir dire. And that was the default position of federal courts all over the country. Now that is changing again. And it's changing because the judges are saying, lawyers ought to be able to do it, and they ought to be able to ask questions, no speeches, no argument, no trying to win your case. But as long as you're asking good questions, I'm going to let you ask the questions. The problem is the lawyers now have lost the ability. We don't know how to do it anymore. There are no CLE courses on it.
Steve, when I present on voir dire, I usually subtitle my presentation, something even good lawyers do badly. And I think your point is well taken. If you don't try a lot of cases, you don't get that, time and grade. You don't get that actual participation time where you can figure out how to ask it. And so many lawyers are scared to ask what they really ought to ask on voir dire. They all want to ask cross-examination questions. They want to ask limited questions that get yes or no answers. What they really ought to learn to ask is, open-ended questions, direct examination questions. How do you feel about this? Why would you make that decision? What is important to you in X? But lawyers don't want to hear those answers. They're scared to do that. So we're lawyers, right? We have clenched hair, right? We are so control-oriented that we don't want to listen to what jurors have to say. And so we don't give them the opportunity.
Ms. Marshall, on your jury, which deliberated, did you think that there was anyone on the jury that should not have been on the jury?
No.
It was a good group and a cooperative group. You didn't have Judge Mixon's problem, a bad juror.
No, we didn't. We had a very thoughtful, diverse group of people, aged from about early college all the way to retirement, different vocations, many employed, some entrepreneurs, including myself. And many of us had reasons we could have pursued being excused more vociferously, but we didn't, because we thought if we ever needed someone to do it, we'd want someone else to, and so we did.
What did you enjoy most about your experience as a juror? What did you like the most about the trial?
Well, our judge took us back to chambers afterward, and she revealed herself much more in chambers to be a firecracker of a person, very involved, very excited about what she did, and just loving it. And I mean, when you say fun, what I enjoy, like I enjoyed that. I enjoyed a lot of my being a juror, but it also was fraught with struggles of listening and trying to remember and being responsible, and so I wouldn't call that quite as much fun.
One more
Yeah.
question.
Go ahead.
What would you tell this group of lawyers that they should do differently,
Yeah.
if anything?
I only had one great experience, but our judge, and I, like I said, I only have one, so things we appreciated. We appreciated that she told us if we would start at 8, she would have us out before 3, and that'd help us. And the point of that was that then we could park and be here, and we could get out of here before the worst of the traffic and the worst of those issues. And she conducted business before the jury trial when we were there, and she conducted business after based on the signs that are posted outside. I don't know any other way. But it was biased, it seemed, as much as it could be, to value us as a group of people who had other things we had to do. Some people were driving from Fort Collins and farther away. And so we just appreciated that we seemed to have a valuable part to play, and yet we were very happy to play that part and stay within our boundaries.
But you said we give every juror who agrees to be on the panel, we send a little questionnaire so we know what their service was. One question is, what did you like least about the jury service? And here's what Ms. Marshall said. Key, having very little framework with which to process and hold the information during trial. And I'd like to explore that with you, because one of the problems that people talk about during trials, I get nervous if I were a defendant with a lot of money at stake, and sitting there listening to the judge orally instruct the jury for 45 minutes, not giving them a copy of the instructions, or giving them only one copy, and using words that I couldn't even understand as a lawyer, and not they get it at the end of the case rather than at the beginning of the case. So, for example, in your case, all the instructions were at the end, right? The substantive instructions came at the end of the case. Would it have been better to give it to you up front? Early on?
I know no pros and cons here, only my experience. My experience was that we all, pretty much all to a person, wrote down almost everything we could remember as fast as it was presented, because we didn't know what any of it was going to be valuable.
Notes.
Yeah, but then, so if we had a framework about, okay, so we can sort as we're listening, okay, that's relevant to my responsibilities here, and that's peripheral.
So let me ask this question to the judge. Give me one good reason, judges, why you don't give every juror a verdict form.
I do.
I do.
At the beginning of the trial. You did.
Not at the beginning.
At the beginning.
Because
Well,
you don't know what claims,
claims go to
defenses,
the
and
jury.
affirmative defenses are going to be proved up.
Yeah.
You need those the factual basis.
No. Really?
Yes.
Why can't,
But Colorado, Steve, they give us a suggested script. And one of them, there are a number of preliminary instructions that almost all of us read to the jury, a burden of proof.
Yeah, those are the standard stuff.
Standard ones.
Yeah, but it helps,
Procedural
if what Ms. Marshall was talking about was context, at least we're giving her some context.
well, if it's a fraud case, you certainly could say, to prove fraud, you gotta prove that the following 5 points, that a statement of fact was made, that it was false when made, that it was reasonably relied upon by the other party, that blah, 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 whatever.
I give them that.
We do.
You do give them that?
Yeah.
I do a
Give them the elements.
preliminary set of instructions
But
prior to
it's-
openings. Prior to openings,
Yeah,
the
they get
the
that.
lawyers and I decide on a preliminary set of instructions at the final pretrial trial preparation jury instructions conference. And what I tell the lawyers that I'm looking for is a very brief synopsis of the claims and defenses in the case. I really want one instruction on the claims and one instruction on the defenses if possible. And then the rest of the instructions are really designed to tell the jurors what their responsibilities are with respect to the trial. One of the things that I'm learning in my dotage is that people who come to court to serve as jurors are not as familiar as they used to be back when I was a trial lawyer with the role of jurors. They don't understand that they can't conduct an investigation. They don't understand that they can't access the lawyers on Google. They don't understand that they can't talk about the trial on social media. And so I use the preliminary set of instructions to remind the jurors of all those responsibilities and to also tell them they can take notes. They can ask questions. They have to submit written questions to the bailiff. And the court and deputy, we call it in federal court, and I won't necessarily promise I'll ask those questions in the course of the trial, but I'll consider them, and they'll hear from me as to whether I intend to ask them of the witness were a lawyer or not, and why. And so I give that information to them in advance, and really it's designed to sort of put them at ease and try to give them a bit of a framework
Yeah.
for what their responsibilities are.
All research has been done that shows that if jurors are told the reason for certain rules, not just the rules, but the reasons, they're much more likely to buy into them and follow. For example, why can't I go to the internet and research stuff?
Talk about that.
Why can't I Google things?
We do, we talk
We
about
talk
it.
about that.
We talk
do.
about that.
Yeah.
All right, well, what is the reason? Why can't I?
Well, the reason is because we want a fair and impartial verdict or judgment based only on the evidence and the law that will be presented during the court, during the trial. Everything else is out of bounds because
Wow.
much of it is informal and cannot be tested either by examination or cross-examination, which would be patently unfair on which to render a decision. I have one question for our juror, if you'll allow me.
Sure.
What did you think about opening statements? Because ordinarily, I trust the lawyers in their opening statements to really flesh out their claims and defenses and highlight that which is going to be significant and why during the trial for the jurors. Apparently, you did not get that aid from the lawyers during their opening statements. Or am I wrong?
So early in the trial, you're a new juror and you're just trying to get a handle on sitting there and listening to everything without ever talking to anybody else. So you're listening, and yes, I'm sure mostly the plaintiff's lawyer fleshed out what he was trying to prove, what his belief about things was. However, I wouldn't say that it seemed to me as a juror that I knew what he was saying, which things were facts, and which things were his proposals to me. And throughout the whole case, one of my biggest challenges was to really try to weed out what is the story I'm being told about the facts, and what are the facts, and what qualifies as a fact. So I don't mean to sound silly.
I've got 2 jurors for you, mister.
Great, come in, please. This is a rare treat. Come in.
Where would you like to have him?
Why don't y'all all sit up here? We're gonna make the room for you.
Sit down, I'll stand.
And have a seat.
Yeah, we got it, we share, we share.
Be in the hot seat. No, you-
So, Judge, I don't know anything about your trial. Will you continue what you were doing up there so we can have the advantage of it? And give us a little,
Kind of speak to this.
this is terrific because this is a juror who was on a case this summer, in June, I think. Now, y'all are hot off the hot seat. So this is terrific. that you came down here. Thank you very much.
So,
Yes.
right here is Trudy and Jesse. Trudy was the foreperson, 7 on the jury. I do 7 on my civil juries. And they just rendered their verdict, and I went and talked to 5 of the 7, and 2 said, yes. Be nice to them.
So, this was a civil case? And how long did the case last?
Jury selection was August 26th, so 2.5 weeks, almost 3 weeks. Yes.
Wow, it's a long case. How long did you deliberate?
2 hours yesterday and about 4 hours, 3 hours this morning, so 5 hours.
And you returned a verdict?
Yes, we did.
For the plaintiff or the defendant?
There were, I think, 4 claims, and 1 was for the plaintiff, and 3 were either not applicable or for the defendant.
All right. And during the trial, did the judge allow you to ask questions, submit questions to the jurors?
Yes, he did. And we had lots.
You did a lot of questions.
Yes. I was concerned.
92 questions.
So, let me give you the experience I had this. So I tried a jury case in July, and the judge allowed the jurors to told the jurors in the open instruction that they could ask questions. But no jurors asked the questions because the jurors didn't really understand what the procedure was. I mean, they weren't given a piece of paper. It's not enough. And when at the end of the trial, I looked and there was a stack of forms on the jury box for the jurors to use, but no one ever used the forms, no one passed them out. It was, the judge would allow questions, but did not inform the jury that they could do it. So y'all had a procedure on it. What caused you, after every witness, did the judge say you had any questions? Is that what happened?
Yes,
He invited it after every witness.
Yes. And I will say I was concerned after the first witness that I was the only one with questions. I was, am I going to be the problem juror? But I think the rest of the jury maybe just wasn't as clear on how the process went, but
Was it obvious? Did the judge do it in a way that it was not obvious who was asking the questions, or did they know you were asking?
I think the problem came with jury selection started on Monday, and then we had to go again into Tuesday, and I'm not sure everybody heard the same instructions, but I don't know. Or maybe they just weren't paying attention. I don't know.
Judge Jackson, of the questions, you said you had 92 questions, 91.
Correct, I number everyone.
Were any of the questions impermissible?
None.
None were impermissible.
I always invite the lawyers up to the bench as they saw it to object if they wanted to object. No objection was made to any question.
And so you like the ability to ask the questions?
Yes.
Almost all jurors do like it. It clarifies for you what's going on.
Yes.
Well, that's great. Now, you were in federal court, so you could not, the judge told you not to talk to each other about the case until you went into final deliberations. The state rule in Colorado is that you can do that, right? You can have, the jurors can talk as long as they're all together in the jury room at the same time.
It depends on the judge. I always instructed my jurors in state court and federal court not to.
Oh, really? Is that-
I always will.
Is that a permissible instruction, Judge, under state law?
It's discretionary. 1:4 in Colorado allows jurors to discuss it, but as Brooke said, it's discretionary. You don't have to do it. I've always done it, but I think it depends on different judges do it different ways.
Well, let me ask you, would you have liked to have had the ability to talk to each other? Let's say the judge told you, I don't want you going back, when you're all together in the jury room, you can ask each other questions about what that witness just said, or you can comment, he had a really bad memory. Or, did he say anything about so-and-so? Those are questions that you can discuss. We don't want you back there saying, I am in favor of the plaintiff, or I vote for the defendant, because you're not to do that till you hear both sides at the end of the case. So would it have been helpful for you to have had the ability, when you were all together, to talk about what the last witness said, or whether you understood what the witness said, or whether the witness said anything about a particular subject? Or would that have been bad?
I think it might have been helpful if there was something one of us picked up on that they thought was particularly important, and to say, oh, did you hear when he said, whatever. I don't know that it really would have changed anything.
Did your trial, when you just finished, did it last too long, in your opinion?
We were all very tired of it by the end, so
You were
I would
tired
have to
by
say
the end.
yes.
And was that because, Judge, do you set time limits in your court? Or not? On what? On the length of the trial, how many hours each side?
No.
You don't do that?
I do not.
So, did the lawyers repeat themselves too much? What?
Judge Jackson was actually very good at
Moving
instructing them
along.
not to repeat themselves too much. I think there was some evidence presented that maybe wasn't entirely relevant to what the actual claims were. That I think when we got to our deliberations and actually started going through, okay, here's what we're deciding, there were huge pieces of evidence and testimony that's not really relevant to this.
Ms. Marshall, did your trial last too long?
No, I think actually they were pretty expedient in getting to us what was most relevant. Although there were parts, once we had the judge's instruction, I was nodding because I would say it seemed like there were other times we listened to something that turned out not to be part of what we had to decide. And but, other than that. And as far as us talking, I think it would help if we could discuss what was said. I think it was good that nobody was airing their not preconceptions, but I guess just personal biases. Because when we first started to have our deliberations, everybody had waited so long to get to say anything that the first thing that kind of popped out was what had frustrated them, including their own personal biases. And it took us like a half an hour, and then we all had to say, okay, no, we really need to look at the judge's instructions and start going through them one by one and saying what's what. And we did.
How many copies of those instructions were in the jury?
Everyone received a copy, and he had them as she spoke to us what our instructions were to go back into deliberation. We had them to see, and any legal principles, we also had that information.
So
there.
each of you had a copy of the instructions. Did you have the same thing? Each of you had a copy of the instructions. How did you select this? What did you say?
I
Did the
think
judge
I had the
select
best
you?
handwriting.
What?
I think I had the best handwriting.
No, come on. Had you done it before?
No, this was my first jury trial. When we went back, Judge Jackson had said, well, you don't really have to stand up in court and talk. You write it down and give it to me. I said if we're choosing on handwriting, fine, I'll do it, but if somebody else wants to do it, I'm not going to contest for it. And everyone else just said, yeah, fine, you're it.
Okay, then let me ask you this question. When you went back, did y'all first take a straw vote, go around the room real quick and take a straw vote about where everyone was, or did you go around the room and talk substantively about your reactions? See the difference of what I'm saying?
I think our first discussion was, how do we feel about the character of each of these witnesses? Was there anyone that we heard testimony from that we tended to discount more because we didn't trust them, or we felt like they were not being entirely truthful, or and then we kind of went through the verdict instructions and said, okay, the last one, we felt like we were all could agree on that. I think the only time we really did like a straw vote, would be when we were trying to award damages. I thought it would be useful for us to each decide, what do we think is appropriate? Let's see, how far apart are we really on damages? That was really the main issues we had to decide.
Judge told you this is phenomenal. I love it, being able to ask you questions. Well, I've been looking for it for 4 years. Hot off the jury. No, it's great. So the judge told you, the whole jury, not to go do any extracurricular research on the internet. You're not to look on your iPhone. You're not to Google anything. Stay off the internet. And that was, and as far as you know, people apply. You didn't. I'm not asking you whether.
To the best of my knowledge, none of us were doing that.
No one was doing it. At least they knew enough not to talk about it.
Right.
So when you go home today, what are you going to do about the trial you just won? No, seriously. Y'all want to know? What were you going to do?
Apparently there was some media coverage of this trial. I may go home and Google what that was.
Are there questions you have about things you're going to look for in particular?
Most of the things that I'm going to look for are really only minorly related to this case. There are things that came up in the background of some of the witnesses that I was like, oh, that sounds really interesting. I want to know more about that. It has nothing to do with what they're doing now.
Did you think the lawyers in your case were evenly matched? Or did one side have a much better lawyer?
I think they were pretty evenly matched. I think one side had more personable lawyers, perhaps.
What do the lawyers on each side, what do the lawyers do that bothers you most? No, if you were instructing a class of young lawyers that work in my law firm, what would you tell them? Don't ever do this, because we hated it.
This guy is from Texas. He asks all kinds of inappropriate questions. Just forgive him.
What would you tell us? Bothered you?
I think what I found grating about some of their questions were the way they posed the question, that it was very, and I'm sure it wasn't intended to be that way, but it came across as mean. That, they're bullying the witness, and to some degree, that's their job. But it just, I don't like conflict, I guess, so.
Okay.
Can
That's good, Ms. Marshall.
Yeah, I'd like to say that, too. There were times when it just felt like the attorney was clearly trying to elicit a certain answer. And when the person on the stand didn't give them that answer, they came at it again. And we could do that for quite some time. And I don't know for all the other people on the jury, but it's like our level of tension would just get higher. It would just be like, okay, let's move on. And I think it is conflict. I think it's really unpleasant to sit there and, I mean, everybody's handcuffed. Everybody has some set of rules they're having to stay within. But especially when it feels like the facts alone aren't proving the point, to have that point reiterated over and over, that's tiresome.
Were the lawyers equally well prepared? I mean,
Yeah. I think there was one cross-examination that I felt like it was a fairly young lawyer that he didn't do as well in that one as he had done in some others. But I never got the feeling that they hadn't done their homework or they didn't know what questions they wanted to ask of that witness.
did the age or gender or anything about the lawyers did you like or dislike? I mean, were they too young, too old, no women? I mean,
No, I
was
mean,
anything about the...
There were young and old and women and men. It was a very mixed set of lawyers. And the one I found the most grating was an older male lawyer, and I just felt like he was, beating a dead horse, I guess. Like she said, if they don't get the response they're looking for, they
Just
keep
keep
asking. If I phrase it a little bit differently, maybe you'll have a different answer.
Well, in the case of ours, we didn't know this, but this whole thing started back in like 2011. And it had seen many rounds by judges and of things. And so witnesses over time gave increasingly detailed answers, which would make some of their earliest answers look like lies. But we didn't know that. We would just have someone compare them to an earlier answer they'd given, us not having any context for why there are all these answers, except for you start putting it together as it goes along. And so that also was not, I don't think it helped in a case to, as it were, at times make witnesses look poorly, like they were intentionally coming and lying to the jury.
Did y'all have any problems with the instructions? Understand? I mean, was there a time during deliberations that you had to go back and ask the judge to clarify something, that you hear something or see something?
I think we only asked one question during deliberations, and that was a question about should we include lawyer fees. Other than that, I thought the instructions were pretty clear.
Right? Do that again. The question was that, so...
See, now you're doing it.
No, this is... So, lawyer fees were not, there was no evidence of lawyer fees, right?
Well, correct. Our question was, if we're going to award damages, should we be
How much of a
considering
cut?
lawyer fees?
How much of a cut does that plaintiff's lawyer get? And do we have to gross it up
Right.
to give? the
Essentially,
plaintiff?
that's what we were
That's
asking.
essentially what you were asking. And you were smart enough to ask that, because we all know, everyone knows that, okay? People know that.
Those lawyers weren't
So
working
what
for
did
free.
what did the judge tell you?
I believe the answer was
Consider it?
lawyer fees will be awarded by the court after trial if appropriate.
Okay.
So no, don't consider that.
Right, well, you got the answer and you went on, you didn't consider it. Interesting. Any questions? Y'all, this is a great opportunity for anyone out in the audience who'll never had this opportunity again to ask questions. Go ahead.
Thank you very much for your service and then also for being willing to give us more time. Before you two came down, we were talking to Ms. Marshall about her experience in the trial that she participated in, and what she was saying is she felt like she had no context, no framework. So through your very long trial, did you feel like the attorneys did a good job of saying, you know, this is why this is important? Or remember?
For the most part, yeah, but there's a few times that it was a little unclear and we kind of had to piece everything together. That's my feeling.
By the end of the trial, I sort of wanted to talk to some of the earlier witnesses again, just because at the beginning we didn't know what questions we wanted to ask. But I think they did a pretty good job in, Judge Jackson introduced us to the case and then opening arguments. They did a pretty good job of explaining what happened. I don't feel like we were really confused about what the issues were or how this all came to be a problem. Does that answer the question?
How many exhibits were there in your case?
Oh my God. I think we had 7 binders.
7 binders. So when you got back there for your deliberations, did you look at any of them?
Yes, I looked at
You
almost
did look
all
at
of them.
Well, how did you do that? I mean, how did you physically handle it? The exhibits are in black binders, and how many were on your jury? 7?
7.
So how do you physically look at those exhibits? I mean, if they're all in a black binder and there's 7 eyes, I mean, it seems...
Well, okay, I'm not sure that all of us looked at all of the exhibits. I think I looked at least a few exhibits from all of those binders. Sometimes we were looking for a specific thing, that we remembered from trial.
Was it hard to find it, what you were looking for?
It would have been nice to have an index.
How about a computer where you all could have been looking at the same thing at the same time? Would that have helped?
I think that might have actually been more challenging because we were all kind of looking for different things at different times. And then, even when we thought we had a consensus on some things and we're waiting for the judge to answer a question about lawyer fees, I think I sat down and started at Exhibit 1 and kind of paged through them and was like, okay, do I need to read this in more detail? A lot of them were almost duplicate exhibits that it was, here's the first draft of this report, and here's the 3rd draft of this report, and here's the 10th draft of this report. And there wasn't a lot of difference between them. So we didn't necessarily examine those in detail. And a lot of them we had been shown multiple times during the trial, so it didn't take a long look because you're like, oh, I've memorized this email.
So this is like, when do you think you made up your mind? Just speaking for you.
Just for me.
Right.
I think about halfway through the defense's presentation, I had a pretty good idea of what both parties had done. Having said that, I had to really read through the verdict instructions to make sure that that was what the actual question was to begin with. But I, probably about 2.5 weeks into this, I had a pretty good idea.
Okay. When
Who
did
I
you
thought
make
was-
up your mind?
I'd say probably, or once we started deliberations, I I had an idea of what was happening. I didn't say yes in favor of either side, but I at least had my own opinion. And then once we got kind of through deliberations, it became clearer, I guess. Because then I had to go back and actually figure out what.
If your question is, when did we decide how much damages we're going to award, that all happened this morning.
That was the last thing you did, is
Yes.
decide how much.
Feedback for our jury, I would say the instructions for a verdict, including what claims were and weren't proven, and specifically what level had to be met to consider a claim proved. We needed that to come to a conclusion about how we would, what our outcomes would be. We all had opinions just based on the massive information presented to us up until then. But those jury instructions and the verdict instructions, we needed those, and we went over them one by one, and we had to look back at the information that was presented in some of the folders. So I can't speak for the other people, but that was my experience of it. We really needed those verdict instructions to clear our way and to come to a legal result.
I will also say that on one of the claims, we were waiting for our lunch to be delivered, and I was still paging through all the evidence because I was the one holdout on one of them. That, I was like, well, I think I know how I'm voting, but I want to make sure. So,
Did things that other people said during deliberations change your mind on anything? Any of you?
Yeah, a few things. It's because it made it more clear getting someone else's perspective. That's also kind of the way I work. I like to get everybody's perspective first and then kind of make the final decision.
I don't know that it really changed our minds a lot. I think, it maybe helped us clarify what our own thinking was. In some
Any of
cases.
you have to watch video deposition?
Oh my God. Yes, hours. Judge Jackson
Hours.
can probably answer more than
How
20
was
hours.
the video deposition?
Yes. One of them was 3 hours long, I think.
What? Did it make any difference?
What do you mean?
That testimony, can you really focus on anything that's going on?
Well, it was over 2 days.
But still.
It made a difference in that some of them were fairly central characters.
Did the lawyers object a lot in your trials? Questions? Were there a lot of objections?
There were
Did
some.
that make you
I
mad?
don't really have
Did you
any
get mad
reference
at
for
any
what's
lawyers
in
for
that.
objecting too much? Or did you just like it? You see them?
I don't think any of their objections I thought were surprising. But I have no frame of reference for what's a lot of objections versus what's a few.
Did Judge Jackson, when an objection is made, does he have sidebars in his courtroom, or did he excuse you, or does he just
There were
say overruled or
few
sustained?
sidebars, but usually it was just overruled or sustained. There were a couple that they had to go talk about.
What hours did y'all work in the trial?
Usually it was 9 to 4:30.
9 to 4:30. And did you get restless? Did you need to stretch?
Well, there were breaks.
Did you spend any time waiting in the jury room very much time or not?
Not a lot.
We kind of had to determine how long we wanted our breaks, so it just kind of picked.
There were a couple times that when they came to get us, Julie, the bailiff, said, oh, sorry, there was a delay, or we had to talk about something, but it was usually only maybe 5 minutes.
Any other questions? Yes, sir.
Yeah.
Please, stand up.
Thank you all three for being here. I have a question about witnesses. In most of the cases we tried, there were expert witnesses. And and I'm assuming you had experts that testified in your cases that are paid large fees for their testimony, which is reviewed at length, I'm sure. And I wonder what your response or the response of the other members of the jury were to these experts and the fact they get paid for their testimony.
And changing careers. Okay, I should probably preface this with, I have a master's degree in engineering and a master's degree in finance. So the experts that were testifying on valuation and statistics, some of them I had some questions about their methods, and bigger questions about how much they got paid for what they did. But some of them I thought provided some valuable context for how important some of these things were.
Was one exercise expert a lot better than the other? Did it make any difference? I mean, a lot of people say you pay all this money for the experts. Both sides pay huge amounts. $500 an hour, $700 an hour, I don't know the experts charge. How much in your case? A lot?
I think about the cheapest one was $250 and the most expensive was like $650 an hour.
Yeah.
And
Did it make a difference?
Not the money-wise, but the expert, we ended up using one expert's information during deliberations a little bit more than another.
Than the other?
Right, some of the experts that presented for us, some of them seemed very theoretical, and over time, it felt like that information wasn't nearly as valuable as what he was charging for it. And then, but in other cases, some of the expert witnesses seemed like that information was very realistic and pragmatic or practical, and it was very useful to have had that as a part of the trial.
I think probably the worst criticism and the one I believed the most about any of the expert witnesses was that they didn't do any independent research, that they took the information whatever side hired them, gave them, and ran with it, and didn't do anything to verify it or confirm it or contradict it. And if all you're going to do is spit out the same numbers you've been given.
So, would you be willing to do this again? I mean, would you look forward to if you get another jury subpoena, would you look forward to responding, being another jury?
If I get another jury subpoena in the next year, I'm going to get excused.
Okay.
If I get another jury subpoena, a few years from now or in a couple years, certainly I would do it again. I would hope for a shorter trial.
What would you do? What suggestion would you make that would make it better for you next time? Any suggestions?
Okay, for me personally,
Yes.
my biggest issue with this jury trial is that my company pays for 3 days of jury duty, and I'm using vacation time. And $50 a day is not much for payment for a jury.
And how many days were you doing it?
We're at 12 days.
12 days. So one thing would help you would be to get paid regular wages.
Yes, I mean, my company told me I can either use vacation or I can take unpaid leave. But $50 a day is not going to pay my bills.
Okay, that's fair.
So,
In other words, it's a financial sacrifice. And
yeah.
if we're going to have jurors like you, we want jurors like you, we need to pay them. We need to figure out a way to pay them.
At least minimum wage would be nice.
Well, and I'm a private practice counselor and I work for myself, and so similar for me, if I lose 2 weeks, half a month of seeing clients, that's devastating too, unless I really have a good back lane, which I know that's my job, but you get the idea. Ours is only 2 weeks, so not as long as yours, but
Still pretty long.
And at the front end, you don't always know for sure how long it might go.
Any other questions? Listen, I want to thank the judges for coming. Judge Jackson, thank you for making this. This is a big surprise, and thank you for coming down here. We have 3 jurors, and it's been great, and thanks for coming. Have a great time.